Getting a divorce in Indiana is actually simpler than you might think. One spouse must reside in the state for 6 months and that county for 3 months before filing. Once the residency requirement is completed, a legal grounds for a divorce must be established. Both general and no-fault divorce are acceptable grounds for divorce. The no-fault reason is irretrievable breakdown of the marriage. The general reasons for divorce are impotence at the time of marriage, conviction of a felony, and incurable mental illness for 2 years. Indiana does not require a parenting plan for child custody. Joint or sole custody is granted based on the best interests of the child and based upon the following factors: the age and sex of the child, the preference of the child, the wishes of the parents, the child's adjustment to his or her home, school, and community, the mental and physical health of all individuals involved, and the relationship of the child with parents, siblings, and other significant family members. Joint custody may be awarded if it is in the best interest of the child, based on the physical proximity of the parents to each other as this relates to the practical considerations of where the child will reside, the fitness and suitability of the parents, the nature of the physical and emotional environment in the home of each of the persons awarded joint custody, the willingness and ability of the persons awarded joint custody to communicate and cooperate in advancing the child's welfare, the wishes of the child, and whether the child has established a close and beneficial relationship with both of the persons awarded joint custody. Either parent may be ordered to pay child support regardless of marital fault based on the standard of living the child would have enjoyed if the marriage had not been dissolved, the physical and emotional conditions and educational needs of the child, and the financial resources, needs, and obligations of both the non-custodial and the custodial parent. Support may include medical, hospital, dental, and educational support. Payments may need to be made through the court clerk. Specific Indiana child support rules and guidelines are contained in the Indiana Supreme Court Child Support Rules. Indiana is an equitable distribution state. The court will divide all property in a just manner, whether jointly or separately owned, acquired before or after the marriage, including gifts or inheritances. Equal division is assumed to be just and reasonable. Marital fault is not a factor, but the following are to be considered: the contribution of each spouse to the acquisition of the marital property, regardless of whether the contribution was income producing, the economic circumstances of each spouse at the time the division of property is to become effective, including the desirability of awarding the family residence to the spouse having custody of the children, the actual earnings and the present and potential earning capability of each spouse, the extent to which the property was acquired by each spouse prior to marriage or through gift or inheritance, the conduct of the spouses during the marriage as it relates to the disposition of their property, and the tax consequences of any property division. If there is insufficient property, the court may award money to either spouse to offset the financial contribution of one spouse toward the education of the other. Maintenance will be awarded to a spouse who is physically or mentally incapacitated to the extent that he or she is unable to support himself or herself, or lacks sufficient property to provide support for himself or herself and any incapacitated child, and must forego employment to care for the physically or mentally incapacitated child. Marital fault is not a factor. Rehabilitative maintenance may be granted for up to 3 years based on the time and expense necessary to acquire sufficient education and training to enable the spouse to find appropriate employment, the educational level of each spouse at the time of the marriage and at the time the action is commenced, whether an interruption in the education, training, or employment of a spouse who is seeking maintenance occurred during the marriage as a result of homemaking or child care responsibilities, or both, and the earning capacity of each spouse, including educational background, training, employment skills, work experience, and length of presence or absence from the job market. Upon request or reasonable possibility of reconciliation, the divorce may be delayed for up to 45 days, and the spouse is ordered to seek counseling. Visit us today at www.mydivorcepapers.com and click on Indiana at the bottom of the page. Let mydivorcepapers.com help you file for divorce today.